Welcome to this episode of Rattling the Bars. Recently, the Supreme Court has handed down a decision about juvenile lifers that might be detrimental to young Black juveniles. Joining me today is head ACLU lawyer, Sonia Kamara, who's going to tell us what this case means and give us a little background on it. Thank you for joining me, Sonia.
Thank you for having me.
Can you kind of give us an overview first of what this case is, where it comes from, and what it means?
Sure. So the Jones case actually follows a pretty recent line of cases that have come down from the Supreme Court where people serving life and their lawyers brought to the court's attention this question of what we do when we're handing out the most extreme punishments, but to people who committed their crimes as children. And so there were a series of cases over the last decade or so that established that when it comes to imposing our harshest punishments, we have to acknowledge the ways in which kids are different. And so the first of those cases really was Roper v. Simmons. And that was a case that established that imposing the death penalty on a child violates the Eighth Amendment. It's cruel and unusual punishment because kids are different, because kids are still forming, because kids don't have control over their environment the same way adults do. Building on Roper, there were a series of cases that involved children who had been sentenced to life without parole. And in those cases, the same reasoning came into play. Life without parole is essentially a sentence to die in prison. And so advocates took the issue to the Supreme Court and said, look, the same reasoning that prevents us from killing children, people for crimes they committed as children, should counsel against imposing this this punishment that we can't undo, where somebody is going to spend the rest of their life and die in prison. And so, in Graham v. Florida, the Supreme Court, in an opinion written by Justice Kennedy, held that juveniles, people who are kids, can't be sentenced to life without parole in non-homicide cases. A few years later, the court decided Miller versus Alabama, which took the reasoning of that decision and applied it to those with homicide offenses. And that opinion was written by Justice Kagan, and what she wrote in the opinion was life without parole for children is permissible only in the most exceptional case, where a judge has established that this is somebody who could never be redeemed. And they use this language that you'll hear me talk about in a moment about permanent incorrigibility, this idea that you could never rehabilitate yourself. Again, this was another 5-4 decision, and that'll continue to be salient. A few years later, the court decided Montgomery versus Alabama, and one of the really significant features of that decision was that it said these recent decisions of our court don't just apply looking forward; they also apply to the thousands of people who are currently serving life without parole in this country. And so the court in that case said, these decisions of our court are so important that they have to be applied retroactively. And what that meant was that was creating an opportunity for people who have been inside for many, many years to have a second chance. And so during this period, and again, and the Montgomery opinion was another Justice Kennedy decision, there was this real sense of momentum in that in the court there was this recognition of that kids are different and that we have invested too much in penalizing disproportionately Black children in our country. So it was really disappointing when the Jones versus Mississippi decision came out. So in Jones versus Mississippi, a 15-year-old boy was challenging the judge's decision to sentence him to life without parole. And the question in Jones was, what does the court have to consider? In the earlier cases, there had been the language of the courts created this sense that in order to sentence someone who was a kid at the time to this really extreme punishment, there was going to be an expectation of a lot of evidence on the record that this was a person who could never be rehabilitated, and that judges would be expected to make really specific findings. In the Jones case, that's not what the court held. In the Jones case, it was Justice Kavanaugh who wrote the opinion, but the court basically, on some level, walked back from these really significant decisions it had made earlier and said, you don't need a specific finding. It's enough to have considered the young person's their youth at sentencing. And so in this way, a lot of us feel like, the Jones case is a reflection of the court walking back from these really important, really meaningful developments that were kind of fuel for sort of revisiting how we deal with the harshest punishments in our society.
Well, let's just look for a minute at the Jones case itself. Previously, the home environment was considered child abuse, sex abuse, suicide attempts, etc. All of these things were taken into consideration previously before this case, before the Jones case. And now you're saying the Supreme Court said none of this stuff has to be considered having an impact on young people?
I wouldn't put it that way. I think what the court was saying was that that state courts have a lot of discretion to consider what they want. Our hope is that the earlier cases of the Supreme Court have helped sufficiently start to change our culture enough so that the impact of Jones is not as dramatic as it might have been otherwise. And I want to take a moment to just acknowledge that, I'm a lawyer, but litigation isn't the answer to everything. Courts are important, but more important, I would argue, than courts is the amazing organizing that has happened around the country by people serving life sentences and their families and their advocates to take those earlier decisions of the Supreme Court and really educate more of our country about the reasoning and the reasons why we absolutely, as a matter of moral imperative, must be considering why kids are different, what environment somebody grew up in, how they could have a future ahead of them that involved giving back to society. So I think that, the language in Jones versus Mississippi was fairly narrow. And a lot of us are hoping that it's an opinion that, it may be slowing down the momentum that we were feeling before the change in the court's composition, but we're not going to let it be the end of this really important movement.
Okay, and I recognize too and respect the work that organizers have done on the ground and through the courts in terms of the amount of states that now have policies that are more reasonable for juvenile sentencing. I think the majority of the states in America now is that. But I understand that there's a small group of counties and states that are responsible for a lot of the draconian punishment for young Black people and young people in general. Is that still the case? Are these states the holdout states? Is this where the work needs to be done?
That's a really good question, Eddie. I think that we need work to be done everywhere. So yes, there are some states where there's maybe a disproportionality, but I want to use Maryland, our state, as an example, right? So in Maryland, we have the blackest juvenile lifer population that I'm aware of in the country. And those racial disparities, I think on some level, a lot of people would say Maryland's a progressive state, right? It's known for that. It's a blue state. But as a practical matter, I think some of the extreme outcomes we see are in progressive states because there's been this sense we don't need to be paying attention to what's happening. So absolutely, there are some jurisdictions that are worse than others. The same is true in any context. So within the state of Maryland, there are some jurisdictions where you're going to find prosecutors and judges that are harsher than others, less willing to revisit extreme sentences maybe than others. But it's just as important to be making sure that we're being attentive not only to the fact that the punishments are being doled out, but also the racial disparities in who is receiving these punishments. And I think it's really important, and it doesn't get said enough, that Maryland beats out states like Alabama and Louisiana and Mississippi in the racial disparities in our prison system. And, you can think about it this way. The U.S. leads the globe in incarcerating people, and Maryland leads the nation in incarcerating Black people.
Okay. But how do you address the issue, say, juveniles, Black juveniles, 3 or 4 times more likely to get harsher sentencing, especially if the victim were white, than white juveniles if the victim is Black? So, I mean, that's some level of institutional racism. How do you address that? That's an individual judge preference, prosecutor preference, lawyer preference. How is that dealt with? Because that's not going away. Well, maybe it will go away. Talk to me.
I think we have to believe, if we don't believe that we can end it, we won't end it. But you're right that it is both individual and systemic. And I think that, the first part of what we do is naming it, right? And I think that there is still so much resistance to naming how racism in any form operates within the criminal justice system, or there's a willingness to sort of generically say it's true. But when we get to the point of identifying specific decision points or processes, there's this, no way, not us, not our system. And so I think that one of the ways is just basic continuing to document the ways in which it happens and talk about it in all kinds of forums. So I know I can be maybe a little bit preaching to the choir when I'm talking with you about this, but I think it's important to be educating the bench. I think there are a lot of lawyers in Maryland who probably don't know that we lead the world in racial disparities in our prison system. And so that's one really, I think, important component. I think another is identifying when we do see systems or tools that are further reinforcing disparities to name them up. And so I'll use one example that I think is very significant in Maryland, and that's the use of risk assessments to decide how risky somebody is. So these are tools. There's a whole industry around sort of algorithms and statistical regressions that theoretically take a bunch of data points about somebody's life, where they grew up, how long, when they were first separated from their parents, whether they got in trouble in school, and then spits out a level of riskiness. But all of that is based on data that is based on our racist, unequal system of justice. So if what we're really measuring when we're saying that a kid who has gotten in trouble earlier has had trouble in school, those are all things that have documented racial disparities associated with them. So that's why when we see a juvenile lifer in Maryland, we see that one who went in, who grew up in Baltimore City, a Black boy who grew up in Baltimore City versus a suburban white boy, right, who grew up maybe in Howard County, Montgomery County, their riskiness is going to look different in the system, not because of anything about them, but because the tools that we're using to assess risk measure their circumstance, and are based on the failures of our system over a long period of time. And so I think one of the ways that we tackle the work that we're tackle these disparities is by looking for those opportunities to where we where we can capture it. And then I also think we just have to be really intentional. And I'll say in our work, we have centered racial equity in how we, in our understanding of what issues Maryland's juvenile lifers face, other lifers face. And I think when you do that, the issues and the potential solutions help rise to the surface. And so in all of these things, it's about educating, it's about saying it in the courts, which I think is incredibly important, to make sure that when judges are making decisions, you might not change their mind the first time or the second time or the third time, but over time, the evidence is cumulative and it becomes harder and harder to ignore.
Sorry, okay, one final question on this Supreme Court thing, because we're going to come back and revisit Maryland in a minute. But the final thing, what can the public in general be doing? As you say, activists advocate, lawyers advocate, grassroots organizers advocate. What can Miss Smith or Miss Hattie do that's got a juvenile in the system? What can the average person do or should be doing?
You mean somebody who has a loved one who's in the system?
Yes, or someone has a friend, or someone's just concerned about the overcrowdedness of the system.
I think it sounds like a small thing, but I think number one is always being informed and also analytical when you are seeing statements from prosecutors or public officials or sometimes even crime victims that our answer is more punishment. I think that's the thing that no person, every single person, we need you to be vigilant about the ways in which those narratives keep us from solving this problem that we're talking about. And then secondly is knowing who your elected officials are and communicating with them about how this matters to you. Because at least for now, that's the system that we have. And if they're not hearing from you, they don't know that you care about it. And most of the time when they're hearing from people about crime, they're hearing from people who want harsher punishments, everybody to die in prison, the death penalty to come back. They're not hearing from people who are saying, I want more sensible, restorative responses to the harms that people have done.
Okay, thank you for that update and that overview. So thank you for joining me.
Thank you for having me.
And thank you for joining this episode of Rattling the Bars.